There it is. Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to hit the subscribe button. It helps our channel grow. For today's misfortune of others, we are turning to intellectual property law, which is my field of interest. Yes, I am actually an intellectual property lawyer, more specifically patent law, but this is trademark and naming rights and maybe some copyright in there, so it's right up my domain. This is something that I have a lot of knowledge in, a lot of experience in, so hopefully that means my commentary will be all that more intelligent and insightful. Well, I guess we'll find out, but either way, we're going to do this thing. This is the case of JLM Couture versus Haley Page Gutman. So a little bit about our players in this story. So Haley Page Gutman is a graduate of Cornell. She went into fashion, and she is a notable designer of fashion, particularly of wedding dresses. She perhaps got most of her notoriety through the show Say Yes to the Dress, and she is a name that is recognized by people who are into those kinds of things, which seems to be increasingly me for some reason, because through the combination of the FBIT series and the Toddy Beauty series, I now apparently am turning into a fashion beauty YouTube channel. I'm not sure how that happened, but apparently it did. So yeah, this is just the continuing path on my fashion beauty YouTube series. Because, you know, whatever. And yeah, so Haley Page Gutman is a designer, and we're going to learn about her. And then we got JLM Couture, the company she worked for, the company she loved, the company that has betrayed her. And we're going to learn a lot about them and what they do and their contracts and their relationships and all that wonderful stuff. Now, as always, of course, I'm in it more for the law than necessarily the tea. But we'll give you a little bit of tea along the way. But there's plenty of channels out there with the drama channels and the reaction channels, and plenty of people out there for your tea-related needs. So a little bit less on the tea, a little bit more on let's actually discuss law. So we're more on the actual discuss law, but we'll try to throw in some fun along the way. Okay, great. So let's do that. So let's get started with the complaint today. Of course, this is an ongoing case. We're doing a little bit of catch up, and we're not going to do it all at once. But today we're going to start with the complaint, at least get this started, and then we'll cover more of the case as time permits. Fun. Okay, great. So here is the complaint brought by JLM Couture versus Haley Page. JLM has a complaint. And they're like, "What do you want to cry about it?" No, actually, we want to make a federal case out of it. Okay. This action for federal and common law dilution, that's a trademark term. Federal common law unfair competition. Conversion, that's stealing. Breach of contract. Conversion. Why are we saying conversion twice? It's also stealing. Trespass to chattels, which is stealing. Breach of fidelity, this is breach of duty of trust in a particular business relationship. Breach of contract, I guess there's more than one. More than one contract we're breaching. More than one conversion we're doing. Breach of fiduciary duty and unjust enrichment. So basically, in short, you have broken the contract with us. You have gained money or other things in an unfair way. You have taken our assets, and you're not competing in a fair way against us. So that's basically what that says in so many words. So, okay. So this court has jurisdiction. Venue is proper in the Southern District of New York. Why not? Let's bring this right in fashion capital USA. Venue is proper in this district because a substantial part of the events and emissions giving rise to this occurred, and the defendant is subject to personal jurisdiction. I guess we can evaluate jurisdiction, but maybe we won't have to, because yeah, this doesn't feel like this is what it looks like when we don't have 85 filings on jurisdiction, and we can talk about other things, right? The court has personal jurisdiction because defendant conducts substantial business within, transacts significant business, regularly does business, derives substantial revenue, substantial part of the events. Let's take their word for it. Sounds good. All right, so who is JLM Couture? It's a company that exists in the state of Delaware because, of course it does, that is operating in New York. And Paley is a natural person residing in New York, and they thoughtfully gave us her exact street address for some reason, but okay. All right, so let's learn a little bit about the factual information, at least according to JLM's point of view. Founded in 1988, JLM is a leader in the bridal design and manufacturing industry, owning award-winning brands, which include Alison Webb, Tia Adorna by Alison Webb, Lucia by Alison Webb. Alison Webb has several different lines. Larzo, Tara Kelly by Larzo, Haley Page, Bluss by Haley Page, La Petite Haley Page, and Haley Page Occasions. JLM designers have won 10 Debbie Awards for design distinction in the couture category, which I didn't even know that was a thing. But apparently there is a thing known as the couture category. I'd like to know what it takes to design in the couture category. Do I dress in a couture way? And if not, how should I change my fashion stylings to dress more in a couture way? I don't even know what it is, but I want it. I want the couture. I need it in my life. And they've won 4 British Bridal Buyer Awards. Somehow that sounds like an insult. I'm not sure why, but okay. JLM operates 12 fashion collections, 9 of which are bridal collections, and 3 others for bridesmaids lines, flower girl dress, and athleisure collection. So far we've learned they're really into the bridal designs. They're basically competing against themselves with 12 different lines. And they have several different people that are working for them, and they're also working under their own name. So whatever the reality is with respect to our immediate participants, we have other participants here who are also potentially in a very similar situation, because they are also using their name in trade and also creating lines that are by them. I'm not sure what the distinction is, but okay. And yeah, they're award winning and they're really, really good at it. So if you're into bridal, contact JLM. You know, not for nothing, but when I think JLM, the name does not scream to me bridal. I don't know if that was their goal, to come up with a name that screams bridal, but JLM isn't really thinking to me, geez, bridal. It's thinking to me, geez, weapons design system. Military industrial complex. Are we designing bridal dresses or missiles, man? Okay. JLM's retail sales are approximately $220 million over the course of 4 years. Well, I guess business has been good for them, so I probably should just shut my mouth and be like, yeah, I guess I just got told. So, okay. Upon information belief, Gutzman graduated from Cornell. That's my understanding too. Now we have an employment agreement, which we're going to refer to. So let's listen to them tell us the tale of the employment agreement. Pursuant to a written employment agreement dated July the 13th, the employment agreement, Gutzman's was hired by JLM on an exclusive basis to be the designer of bridal dresses, bridesmaid dresses, evening wear, and related apparel to be sold and manufactured by JLM. The employment agreement was entered into when Gutzman was relatively new to the fashion industry. Pursuant to Section 1 of the employment agreement, the term expired on August the 1st, 2016, unless it was terminated sooner, or JLM exercises options to extend the term of the employment agreement for 1 additional year or additional 5 years, although, as set forth, it had been late extended and amended. Okay. Interesting. They'll be interesting when we get into the details of the contract in terms of this ability to extend the agreement, because we can get into, like, you know, most contracts, of course, most contracts for employment, as I'm sure you're aware, are at will employment, but that's not a universal rule, right? Even there's no such thing as like an at will state. You might hear this term bandied around, like at will states, and that's just like talking about default rules. And most states are at will, but you can have contracts that are not at will. You know, most contracts are your 90%, 95%. I don't even know what the number is. If you think about all the jobs that exist, 99% maybe are at will. But yeah, if you have particularly notable employees, particularly notable things, you can have not at will agreements. That being said, however, if you try to get someone to continue to perform on an agreement, on a personal agreement, even if it's not at will, you run into 13th Amendment problems. So there are issues there to be had, but we'll analyze those as they come up. Because you can't really force someone to work for you. You may be able to prevent them from working for someone else, but you can't really force someone to work for you, particularly when there are personal services. So yeah. Unless you're buying like a company. If you buy a company and they're the employee of the company, then you get the company to do business for you. So this is where things get complicated, and you have to maintain the balance or maintain the separation between business and person, right? So if you have a sole business, like you have a sole proprietor where the business is the proprietor, you can force the business to do work for you. You just can't force the person to do work. So if you have a sole proprietorship, then that means as a practical result of that, you have a problem. Because now you have to hire someone to do work for the business to fulfill the contract. So businesses can be forced into ongoing relationships, just not people. So if you have a contract with a sole proprietor, you may not be able to force that person to do stuff, but you can force the business to do it, even though at some level they're one and the same. It just means go hire someone else and make it happen because it's now your problem. So, but we can deal with that later. Excuse me. The employment agreement was still in effect as it was extended by JLM pursuant to written amendment and pursuant to JLM's notice, in which JLM exercises options to extend the term of the agreement for at least additional 3 years. Pursuant to the amended agreement, Gutzman's duties remained the same, except she was also responsible for designing the gym. I'm not going to get this right. I'm not even going to try. Let's call it the gym, bridal, and occasion lines. The employment agreement, amended agreement, and option notice are sometimes collectively referred to as the agreement. Pursuant to Section 2 of the agreement, Gutzman's duties include, but are not limited to, being a designer of a line of brides and bride dresses. Let me just move this real fast so I can see what I'm doing. Excuse me 1 second. Thank you. Further, at GLM's request, Gutzman's is also designing evening wear. Each of Gutzman's designs sold by GLM under the brand name of GLM's choosing, and Gutzman's was a direct responsibility over her designs. Further, in addition to designing apparel for GLM, Gutzman is also required to perform additional duties and services commensurate with her position as a designer, as may be assigned to her. Yeah, this is the kind of language that's not atypical on contracts, but it's kind of language that should give you a little bit of pause, because what that looks like may be substantially different. But this kind of loose language is not atypical for these kinds of contracts. These additional duties include, but were not limited to, Gutzman's traveling trunk shows, traveling overseas to supervise the manufacture of apparel, and assisting with JLM's advertising programs, which I'm assuming means something like modeling or helping with modeling or promoting modeling or something. Further, Gutzman is to devote her full-time attention to JLM's business during her business hours. And while she is employed, she will not, without prior consent of the president or board of directors, engage in any other business enterprise which requires the personal time and attention of Guttman, and would interfere with the importance of her duties thereafter. This is also really, really typical, and even if it's not in the contract as such, it's kind of one of those implied things. Because of course you do. Like, whatever else you might do anywhere else, you have a duty to perform on this contract. So even if you never said it in the contract, and you definitely should, but even if you never said it, it's kind of an implied term. Of course, you can't take on responsibilities that would prevent you from performing on your contract, because then you'd be in breach of contract, and you have to fulfill your contract. So that's not only typical, it's kind of implied. Pursuant to Section 10, Guttman also granted JLM the exclusive worldwide right and license to use her name, Haley Page Gutman, Haley Page, or any derivative thereof, collectively designer's name, in connection with design, manufacture, marketing, and or sale of bridal clothing, bridal accessories, and related bridal and wedding items, including all goodwill associated therewith, and the terms thereof. So the first thing I will take note here is that, at least in this section of the agreement, it only refers to bridal clothing, bridal accessories, and bridal and wedding items. So that's the first item of immediate note, because JLM themselves have said that Haley Page's duties extended beyond this, right? They extended to like evening wear and other stuff other than bridal. But the rights that JLM got, at least according to this section of the agreement, with respect to her name, only extend to the design, manufacture, marketing, and sale of bridal clothing, bridal accessories, and related bridal and wedding items, and not presumably to evening dresses or like any other kind of clothing. So I don't know if there's any other provision of any other agreement that would say otherwise, but she would, at least according to this language, be able to use her name in connection with the design of like literally any other kind of clothing. Because she only gave up her naming rights with respect to bridal stuff and wedding stuff. And there's a lot of things beyond that. And also, depending on how cute she wants to get, we could then have debates about what bridal and wedding items are, right? Because what's the difference between a bridal dress and any other kind of dress? This is where we get to play metaphysics. And we get to have, this is where lawyers get to have lots of fun. What exactly is a bridal dress? What exactly is a wedding dress? Now, you probably have a picture in your mind of the typical bridal dress. And you say in your mind, if I know what a bridal dress is, and I'm as a lawyer, I'm like, are you sure? Are you sure you know what a bridal dress is? You sure? Really? Are you really sure? Are you really sure you know what a bridal and a wedding dress looks like? I don't know, man. This is where I, as a lawyer, get interest. This can go both ways, of course. This is where, if I'm JLM's lawyer, I start to try to say all the things are bridal dresses, and then if I'm Gutman's lawyer, I say none of the things are bridal dresses. Right? This isn't a bridal dress. It's merely a white dress. People wear white dresses other than weddings, and it's got some flourishes on it. People have dresses without flourishes, and it's just, it has nothing to do with weddings. It's just a white, eloquent dress. See? See how you get to have fun here in law land? This is what lawyers get paid for. Do you know what a bridal and wedding dress is? Are you sure? Are you really sure? Yeah. Pursuant to Section 10, Gutman irrevocably sold and assigned and transferred all right, title, and interest to JLM that now exists or may exist during the term and any extensions thereof, and for a period of 2 years thereafter, to register the design names or any derivatives as trademarks or service marks with the USPTO. Okay. So she sells all right and interest that may exist, and for a period of 2 years thereafter, to register the names or any derivative names with the USPTO. In the right categories, yeah. Sure, that makes sense. As additional inducement, once they are registered, Gutman commented that the trademark shall in perpetuity be the exclusive property of JLM. And Gutman shall have no right to use JLM trademark design names or any confusingly similar marks or names in trade or commerce during the term of employment agreement or any time thereafter without express written consent. Okay, yeah, I'm already seeing possibilities in my mind, because when you're saying, okay, you can register trademarks, right? I'm like, okay, but you can register trademarks, but the trademarks in question, at least respecting to the name, Haley Page's name, right? So there might be any number of trademarks that don't relate to her name. And so those trademarks we can argue about somewhere else. But any trademarks that are derivative of her name, right? She's only given a license with respect to this aspect and not other aspects. So that would mean possibly she'd be able to contest those marks with respect to other domains because it's outside their rights. So she might be able to run a business with her name in the fashion industry in non-bridal dresses, and she could sue and saying that the trademark is overexpansive. This is where the lawyer in me goes. It's like, aha, I can attack this. There's wiggle room. For good and valuable consideration, which is very legal speak for we gave you something of value, anything of value, $1, which was acknowledged by Gutman. Gutman also agreed to these restrictive covenants, agreed to restrictive covenants set forth in the employment agreement. Gutman agrees to the following: not to compete directly, indirectly with JLM, not to solicit an employee of JLM or JLM subsidiary for the term of the employment agreement and 2 years thereafter. That's a very reasonable term. A 2-year non-compete clause, I can't see any problem with that. You can't compete with us for 2 years. You can't poach our people for 2 years. That seems reasonable. And in perpetuity, not to divulge any confidential information. Well, that's also completely right. It's JLM's information. She can't disclose that ever. It doesn't belong to her. So yeah, that's perfectly fine. I don't see any problem in that. In Section 9 of the employment agreement, Gutman acknowledged that in the event she breached the agreement, that she consented to granting of a temporary permanent injunction against breach by her against any court of competent jurisdiction, prohibiting her from violating any portion of the agreement. Yeah, I guess, but then you still have the underlying problem of, did you breach the agreement? And then you have to get into contract agreements, which goes into the likelihood of the merits. So I'm not sure what this language is really doing for you. But sure, let's have it in there anyway. Gutman also acknowledged that JLM will not have adequate remedy at law in the event of any breach and will suffer irreparable harm if she breaches any provisions. Well, that would be a standard in the injunction. Like the fact that you don't have any compensatable damages is an element of the injunction standard, right? So if they're compensatable, you can't get an injunction. If they're not compensatable, you might be able to get an injunction. I'm not sure necessarily conceding to it is dispositive because it's a legal standard, but it doesn't hurt to have it in your pocket. The provision as drafted is not limited to any breach of Section 9 of the employment agreement. It applies to any breach, period. Okay. Pursuant to Section 11 of the employment agreement, all of Gutman's work product that she created, including but not limited to designs, drawings, notes, patterns, sketches, samples, or improvements to existing work and any other work conceived of or developed by Gutman in connection with her employment, including bridal-related clothing, accessories created by her employment, including all designs created prior to the execution of the employment agreement. And that's an interesting aspect there. All designs created prior are deemed to work for hire. I'm not sure if that works legally. Now, anything she created during the term of her employment can be a valid work for hire. That's true. But anything that she created prior to employment, they can't just say it's a work for hire. That doesn't even make sense. Now, what they could do, let me back up one step. I said prior to the agreement. I misspoke. What I should have said is prior to them working together. So if they were working together at some point prior to the written agreement, then yeah, that could maybe retroactively be put as work for hire. And maybe it was work for hire the whole time. So, but if they're saying like stuff that you came up with before we ever entered a relationship with each other, then no, that doesn't make sense because it's not a work for hire because she wasn't hired by them. Now, what they could do instead is say that you're agreeing to assign us any intellectual property and work before. That would be fine. It's like, so you're agreeing as part of this agreement to give us any intellectual property rights from before, but you can't just retroactively declare it work for hire. If you came to me this as a judge and like, here's some work that existed before they ever started talking to each other, and the contract says it's work for hire, I'm like, no, it's not. Because that's ultimately a legal conclusion, right? It's a legal conclusion. You can't just agree to this thing. It's like, as a matter of law, no. You can agree to a lot of things. It doesn't necessarily make it true, right? It's like, no, that doesn't work for me. All right. To the extent the designers were not deemed to be work for made for hire pursuant to copyright, all rights and renewals therein were assigned to JLM. Okay, fine. Great. That's the better way to do this. So we're making it work for hire, and if not, all the rights are assigned to JLM. That makes more sense. Further, all ownership to any intellectual property arising of and related to the designs were deemed to be sole and exclusive property of JLM. Fine. Anything she created during her employment is her employer's. That's what she was being paid for. Things you create for your employer are their stuff. It's not a super deep concept. That's why you're getting paid. Shortly after the execution of the employment agreement, JLM began using the designers' names as providing the agreement to sell and advertise clothing designed by Gutman. For example, JLM exercises rights to use the designer's name to create brands or labels under which it would sell clothing and apparel. The main brand name that JLM created to sell such clothing was Haley Page, the Haley Page brand. JLM also created additional brands under which Gutman clothing and apparel will be sold, including Blush by Haley Page, La Petite Haley Page. Just on a purely note of personal interest, and I don't know if there's an answer to this question to be found, but why do we call it La Petite Haley Page instead of La Petite by Haley Page? I mean, it doesn't matter legally one way or another. I'm just kind of curious. Someone somewhere had to make a decision. I'm just curious why they called it La Petite Haley Page instead of La Petite by Haley Page. I don't know. And Haley Page occasions. Why have they called occasions by Haley Page? These are the questions I wonder. Doesn't matter, just kind of curious. Each of these brands, including Haley Page brand, are sometimes referred to as HP brands. Okay. In order to protect JLM's rights and investment in each of the brands, JLM began taking necessary steps to protect the trademark rights in designer names that obtained from Gutman in the employment agreement. In September of 2011, Gutman exercised a trademark registration announcement, which she acknowledged that she transferred, sold, and assigned all the rights in designer names, Haley Page, and derivatives there, to JLM, which she already agreed to do as a matter of contract, so sure. Gutman, but then again, it might be exactly as what the scopes of these trademarks are because of the naming rights issue, right? So we covered that a little bit earlier. So she could potentially sue if she were so inclined. Now that the relationship is broken up, she could potentially sue on the basis that the trademark extends to more than she actually sold. So the trademark needs to be modified to be limited, assuming it's not already limited. Maybe it is already limited and it's a moot issue, but just an item of note if anyone's paying attention. Gutman executed additional consents for JLM to file registrations for designer names that were subsequently filed. Okay. JLM has subsequently filed trademark registrations. JLM filed for the first registration on some dates in a particular class, on a registration number, in this class, registration number, blah, blah, blah. Yeah, we have a whole bunch of registrations and a whole bunch of different names. We could look them up and pull them up all individually, but sure. In addition to the U.S. trademarks, JLM owns approximately 27 foreign trademark and 2 foreign registration for the designer names. Okay. As part of the overall marketing strategy, JLM had various social media accounts created, which are included but not limited to the following: Miss Haley Page, as well as other social media accounts and other platforms. So if JLM themselves created the account and it was part of their corporate account, that's more suggestive of being a corporate asset. Even if sometimes she was posting personal things on them. Right? So if it's a corporate asset, even if she's posting personal things, if it's a corporate asset, then okay. If the corporation doesn't care, then, still corporation asset. The corporation is in control. If they don't care, they don't care. JLM has also owned several domain names related to it, HaleyPage.com and MissHaleyPage.com, which are controlled and owned and used to promote these brands. Again here, if they are not exclusive to wedding and bridal, that might be overly broad based on the language we saw before. JLM's use of social media is an integral part of advertising strategy, so it is for everyone these days, which creates name recognition for and advertises these brands, including HP brands. To this end, JLM embeds links on its various websites and social media accounts. Also embeds links on each of its social media accounts to other social media accounts. Additionally, JLM has also advertised each of its brands in various print and online advertisements and display. Yeah, so this is just basically going to show that we have used these brands and we have built up a lot of corporate equity in them. And also that it's our equity. Now, I'm not sure, strictly speaking, this matters legally, but it's helpful, right? Anything that's helpful is good. So these things have value, and they have value because of things we've done to give them value. It wasn't solely because of Haley Page that they have value. It was because of us, maybe primarily because of us, that these assets have value. And so they're going to show that they have an equitable interest as well as a legal interest in these assets. So to the extent it matters, then they're showing that. And it always helps to show, that we have an interest from something we actually built. We built this, so it's ours. It doesn't hurt. In 2015, not earlier, JLM began adding the main IG account name as well as other social media accounts to hang tags on each piece of clothing. Hang tags are removable pieces of clothing. Removable tags. I know what a hang tag is. Hang tags are used as source identifiers, and frequently are specimens used to prove commerce. Sure. So a specimen here is just a technical term. It just basically means anything that you submit to the patent office or the trademark office, which are the same thing, the patent trademark office. So you submit to the trademark office to say that this thing is in fact a good on sale. So a hang tag is evidence that it is in fact on sale. The hang tags were used for specimens in 3 of the trademarks, and 2 of which had the main account name on them displayed. Okay. JLM's advertising strategy also creates brand loyalty. Further, the marketing strategy also increases the number on each social media account. And this is one of the key goals, as you would imagine. Of course, the goal is to increase the amount of traffic we're getting on our social media accounts. We want more people to see our products. We want more people to visit our webpage. We want more people to buy our stuff. Of course, that's a goal. The number of followers of each social media account, in particular of the Haley Page accounts, has significantly increased. For example, with respect to the Haley Page brand alone, they expended approximately $4 million on advertising since 2012. Again, this is going more to the equitable side of the equation rather than the legal side of the equation, and showing that they have invested, and so they have an equitable as well as legal interest in this property. The Instagram platform is particularly important in bridal fashion, as Instagram posts are mainly photographs. Well, for whatever it's worth, I made an Instagram video earlier today, so you can check that out. Beautiful wedding photos and beautifully curtailed images of models wearing wedding dresses and bridal dresses, which are prominently displayed on the main account, are what potential customers want to see. Women see their dream dress, designed by Gutman, on their main Instagram account, which is the primary reasons they become followers of the account. As a direct result of the marketing and advertising expenditures, the number of followers has increased. For example, the main Instagram account only had 22,000 followers, and then it had 49,000 followers, and then it had 88,000 followers, and then it had some other followers, and now it has 1 million followers. So we've done a lot to grow this brand, from 22,000 to 1 million. We've invested a lot of time and energy in it. So, Plants have undertaken significant effort to protect and ensure its continued ownership and control over social media accounts, including JLM, and content, the creative content therein, used in advertising. JLM has developed a reputation among consumers as a design house for premier and upscale wedding attire. It never hurts to sell yourself in your complaint. I mean, you don't want to overdo it because it becomes obnoxious, but an oblique line once in a while to be like, we're the shit, is always a good thing. JLM is trusted and depended on by its consumers for the most upscale stuff. Also, we're having a 20% discount. That would be good. No, I like that. No, I think that would be the baller thing ever to do. That would be the most baller thing ever to do in a complaint. And then I've dreamed up the idea. I want to actually try it someday. I don't know if I'll have an occasion to, but that's the most baller idea I may have ever had. Yeah, so JLM is the premier designer of wedding dress designers. And for everyone who's reading this complaint, until June 2021, we are having a 20% sale. Redemption code is JLM lawsuit. This is the best idea I've ever had anywhere. Why don't we put a discount code in the lawsuit? I love it. I love this idea so very, very much. If I ever have the chance, I'm going to do it, man. I'm going to put a discount code in the lawsuit I write. This is awesome. This is the greatest idea I've ever had, man. See who the real fans are. To protect the value of HP brands and intellectual rights therein, JLM must make sure the content of social media accounts, including JLM, contain beautifully photographed images related to the bridal industry and designers, such as Gutmann, the designer of these brands. Gutmann initially performed as required on the employment agreement, not only performing her services, but also assisting in advertising. You know, this is the ultimate truth of contracts. This is the ultimate truth of contracts. The ultimate truth of contracts is you don't need contracts when everything is going good. When everything is going great, you don't need contracts. Contracts are very specifically for when everything goes to shit, so that everyone is clear and no one's like, well, you told me this, you told me this. As long as everyone's happy, you don't need contracts. Contracts are for when someone is unhappy. Most, if not all, the first posts on the Instagram account related to the JLM to Gutmann's designs, the bridal industry, and bridal trunk shows. From the time the main account was created, JLM owned the main Instagram account. Further, until Gutmann changed the account password, that's a no-no. If it's a company asset, that would be what the conversion aspect of that would be, by the way. Also on Just Enrichment, that's a twofer. You've converted it because you've stolen it, and you've become unjustly enriched because you've stolen it. So, now, JLM had full access to the account, and JLM maintained and posted the account. Sometime in 2014, a Pinterest social media account was also called Miss Haley Page. JLM owned this account, and the content of the account has always been bridal and wedding related. As long as it's bridal and wedding related, you don't have as much a problem. And then we have a definition of a trunk show, which is not the worst idea because, of course I know what a trunk show is. I'm a super sophisticated clothing guy. I love fashion. But for anyone who doesn't know what a trunk show is, which isn't me, they've thoughtfully included a definition for you plebes. So for those of you who didn't know, a trunk show is an event in which vendors, such as JLM, present merchandise directly to buyers for stores and individual companies at venues and showrooms. So now you know what a trunk show is, just like me. Gutmann was not only contractually obligated to assist in the advertising and marketing, but she had additional financial incentive to do so. She received additional compensation. So as she was hawking these goods, she got a commission. How nice. It was agreed and understood by Gutmann at the time that the account was created that the account was owned by JLM. Gutmann was responsible for posting content that related to her designs, bridal industry, and trunk shows. Also, Gutmann was responding to direct messages from people who followed the account. The purpose of responding to DMs was to generate buzz brand loyalty for Haley Page brands. Gutmann, however, was not permitted to post content related to a competitor's products, non-bridal related products, and services and personal matters, unless these posts were endorsed by JLM. As further evidence of the importance of the main Instagram account, and that Gutmann understood the importance of this, the signature in her business emails indicates the main account, business address, and indicates Haley Page and blush trademarks. So apparently this is her signature on her emails. Haley Page, head designer, at Miss Haley Page, with a little sketch of a bridal dress. Nice. It was also agreed that JLM had control over the account. For example, until recently, JLM had the password. JLM used it to access the main Instagram account. JLM expended its own funds to maintain and update the account. For example, JLM employees at JLM's expense posted to the main account. Some of these postings were at the direction of Gutmann, who was responsible for making sure that up-to-date, relevant content was posted. Other postings were made by JLM employees at the direction of other employees in marketing. Regardless of whether Gutmann or other employees were maintaining the account, from the day the account was created, Gutmann actively worked with JLM to improve and add posts to the account. Yeah. I mean, she was kind of obligated to, right? It was their asset. It was the company's asset. She's an employee. Go help us promote stuff on Instagram. Yeah. In fact, on or about of 2019, Gutman sent an email to Joe Murphy, JLM's president and chief executive, requesting JLM to hire a social media director to run the account. JLM also paid for items to be given away to followers of the account, such as wedding dresses. I think JLM should pay to be for. I think JLM. I need a sponsor. I need to get a sponsorship from JLM. That's what I need. I need to get a sponsor deal from JLM for this entire lawsuit series. Yeah, this entire lawsuit series should be brought to you by JLM. I need to work on my I might need to work on my ad pitches for JLM. Haley Page dresses are nice, but have you seen this line? Here's some other fashion choices you have, and right now get 10% off with the coupon code Uncivil JLM Alliance. JLM, if you're out there, call me. This entire lawsuit series can be sponsored by you. It's yours. We can have the logo on screen, ma'am. It'll be great. I'm also accepting offers from Gutman. Let's see who gets to me first. Will it be JLM or Gutman who will sponsor this series? Who will find out? Over the years, Gutman has been working for JLM. Sales of Gutman's clothing and apparel have continued to steadily increase. These sales were in large part the result of JLM's campaign, as well as the quality of their clothing, which now have a 10% off code. In fact, in 2014, JLM and Gutman executed an amended agreement, which, although did not supersede the agreement, it, among other things, increased the amount of consideration, which is a legal term for pay. The amount of consideration, otherwise known as her pay, and required her to perform additional responsibilities. Under the term of the amendment, the term thereof was extended to 2019, unless terminated or extended. JLM has also actively pursued and obtained lucrative cross-marketing agreements. Not with Uncivil Law, they haven't. I'm the most lucrative opportunity of all, man. JLM is slipping. And tie-ins to capitalize on Gutman's growing recognition in social media. Or, maybe I should just get sponsored by Gutman over here, because, Haley Page over here, she's the underdog. She needs someone who's promoting her products. So we get some sponsorship from Haley Page for her designs. That'd be good. If you're out there, Haley, holla. For example, in about 2015, JLM's chief executive officer used to have connections to have Gutman and her then fiance, Danny Wallace, placed on the cover of the Knot magazine, an important magazine in the bridal industry. Why would they call a magazine in the bridal industry the Knot? I don't get it. Mr. Murphy used his connections at Kleinfeld Bridal, one of GLM's biggest customers and location of where Say Yes to Dress is taped, to have Gutman become one of the regular feature designers on TLC's Say Yes to Dress, which only served to increase the popularity of the HP brands. And before anyone starts typing really arrogantly in the chat, yes, I got it. I was deadpanning. Hopefully you figured it out and you're not about to embarrass yourself by trying to explain it to me. Let's see if you do. That was too much fun. Thus, resulting from Mr. Murphy's efforts for approximately 2015 to present, Gutman has featured on Say Yes to the Dress to promote the HP brand. Additionally, from 2018 to 2019, Gutman was one of the featured designers on TLC spin-off Say Yes to America. Gutman's appearance on television generated additional interest for the HP brands. JLM's effort was to benefit the HP brands, not to provide Gutman a platform to sell or endorse goods or services that were unrelated to and approved by JLM. Gutman's increased notoriety for her television appearances also resulted in collaborations and co-marketing ventures between JLM and third parties. For example, on or about 2018, JLM entered into a collaboration agreement with a jewelry company called Hearts on Fire Company. Pursuant to said agreement, JLM granted Hearts on Fire the right to use names Hearts on Fire by Haley Page and Haley Page for Hearts on Fire. Those are two very, very similar names if we're trying to go with different ideas. With respect to approved wedding bands and wedding rings, JLM was required to provide Gutman for marketing purposes for products under the collaboration name. Hold on one second. In furtherance of the collaboration agreement, Gutman executed a letter of inducement, where Gutman agreed to, among other things, the reformers required in the collaboration agreement. As a result of the collaboration agreement, JLM has received royalties from Hearts of Fire. In addition to these payments, the joint marketing of Haley Page trademarks and Hearts of Fire's name under a collaboration agreement have generated additional goodwill for JLM's designer names, related trademarks, as well as the social media accounts. On or about February the 2nd, Joe Murphy of JLM provided Gutman with the option notice required under the amendment agreement that it was exercising its option to renew the term for additional 3 years. As sale of the brand goods were so successful, Murphy offered to negotiate further to amend the employment agreement to increase the term and provide with additional financial compensation. In August and September of 2019, after Gutman had requested that JLM hire a social media director to manage and operate the main Instagram account, Gutman continued to utilize a team of JLM employees to assist her in running contests for post the account as well as post on the main account. You guys are a lot of fun. I only tease you because I love you. Yeah, to quote the Friars Club, we only roast the ones that we love. Despite the success of HP brands and in stark contrast to the prior cooperation and collaboration with Gutman regarding JLM's ownership and use of main account, Gutman began to take steps not only to assert control over the property, but Gutman took steps that resulted in damage to the business and intellectual property rights. Issues with Gutman began in 2019 when Gutman created a TikTok account under the name of Miss Haley Page and subsequently posted videos that did not properly represent HP's brands. The name is one of designer names, and JLM has used it continuously in commerce since 2012. Consumers who follow these social media accounts, which utilizes Haley Page's U.S. trademarks, do so because they want to follow the wedding designer gown collection. As such, they expect to see premier wedding attire and related accessories that are consistent with JLM's image. Customers who follow the social media accounts expect to see premier bridal attire under the umbrella of JLM. When Joe Mercy advised Gutman that she should post JLM-approved content on TikTok rather than posting personal images, Gutman responded shortly thereafter by changing the password no longer to access account. Yeah, see, I think actually JLM might actually be in the wrong here. Because by the terms of the contract, right, the use of the name only extended to wedding and bridal designs. That's the language they quoted, right? He gave her the use of the name for the purpose of wedding design. So if she's having her own personal account, as long as she's not posting anything relating to wedding design, she may very well be in the right here. With respect to the TikTok, she may be less in the right with respect to, stuff, yeah. Upon information and belief, Gutman changed the biography section of the main Instagram account read personal and creative account. Yeah, that might not be a good sell. Gutman removed efforts to JLM. She might be able to do this on TikTok. And she can probably use her name on TikTok because of the contract. She has a better argument there, that's for sure. Despite Gutman's action, Gutman continued to work for JLM as a designer, and JLM's continued to honor its obligations under the employment agreement and amendment agreement. Further, Gutman locked JLM out of the main Instagram account. Gutman continued to post content as requested by JLM. However, in June of 2020, during discussions between Joe Murphy of JLM and Gutman, Gutman informed JLM that her position in the main Instagram was her personal account. Well, if it was created by JLM while she was employed by JLM, posting things by JLM, I mean, it's probably their account. Probably. Especially if it's bridal and wedding exclusive. Except for the things that Haley herself posted. So Haley herself posting things doesn't count. But as long as what JLM was posting was bridal and wedding related, you know. Upon information believed shortly thereafter in or about, and it doesn't have to be explicitly wedding related. It can be tangentially. So if it's like, you know, please attend the trunk show and Haley Page will be appearing, you know, without more, that might be sufficient because the overall context suggests bridal. So you need something, you know, that wasn't oblique. You need something a little bit more clear that wasn't referring. Upon information belief, and shortly thereafter, in and about July 2020, Gutman began posting personal images, in addition to bridal images, as well as uploading posts promoting the goods of third parties, such as olive oil, beer, and nutritional supplement. To the main account? Nah. For these unauthorized posts may appear JLM is associated with or endorses these goods when it does not. That can be a host of problems for JLM on a purely legal level. It's not even just an issue of controlling their own brand, as important as that is, but it can be a legal problem. If JLM is seen to endorse a product or promote a product and that product goes bad, right, at least theoretically under the right circumstances, JLM could potentially have some kind of responsibility there. Or even if they don't have a legal responsibility, they could have a negative side effect. So like if they are seen to promote, I don't know, Corona beer, and then the coronavirus happens and Corona stock sinks, then maybe JLM stock sinks even though they never promoted it because it looked like they did, right? So there's some liability issues there on a legal level. There's some liability issues there for tarnishment. There's some liability issues there for confusion. There's liability issues there for tying yourself to something that might go bad. So, you know, there's either, you know. But by July of 2020, the main Instagram had 1 million followers. By taking possession of the main account, Gutman now had instant access to 1 million followers, where she could promote her relationship with third parties without authorization or permission, at JLM's expense, as JLM had expended substantial time, effort, and money into increase the followers. Upon instant information belief, Gutman had paid for these endorsements and therefore profited off substantial investment. So that would also be an unfair enrichment too, because if she is using the company asset to gain endorsements, then the money also belongs to the company because she's an employee of the company. The Instagram is a company asset. And so if she takes the money, she is taking money the company that's the company's, in addition to all the other problems. So the company doesn't want you to do this, and the revenue that came from it is also theirs at the same time. Yeah. Starting in the summer of 2019, JLM and Gutman increased descriptions regarding a new agreement. Discussions continued until recently. JLM believed that Gutman's decision to take over the mini Instagram was a negotiation tactic to obtain leverage, which, you know, because it's a company asset, it's kind of a piss poor leverage strategy because you're using what your leverage is things the company already owns. Not great leverage. Nevertheless, JLM believed Gutman would return control as soon as the account agreement was reached and Gutman restarted posting JLM approved comment. JLM took no immediate action. which is a perfectly reasonable course of action, right? If JLM takes action, that could create problems unto itself, right? So sometimes the best course of action is not to do anything right away. And that's a perfectly understandable choice. So the fact that they could have done something sooner and they didn't is perfectly understandable. So, no problem. In fact, of October 2020, following a meeting at Kleinfeld between Haley and JLM, Joseph Mercy, during which Murphy emphasized to Gutman that was her duty to the company to include links to the website, Gutman restored the links to the account. Unfortunately, on or around November 3rd of 2020, a fit of anger after Gutman found out that JLM was not willing to give her the main Instagram account because it's a company asset as far as JLM is concerned. They created it. They developed it. They poured a lot of money into it. They had their workers building it. So it's a company asset as far as JLM is concerned. And at least on their own complaint, and let's make this 100% clear as well, right? We didn't really give this disclaimer earlier on, so we might as well give it now, right? This is written from JLM's point of view to be the best possible light for JLM. So everything they say, we can assume is true, but is puffed up. They are emphasizing good facts and diminishing bad facts, right? So what they're doing, if they have a competent lawyer, is they are heightening facts that are helpful and burying, if not failing to mention, facts that are not helpful to them. So there might be facts that would counsel against this, which they're not going to tell us about. But that's okay. They're just trying to make a prima facie case anyway, right? So on a prima facie level, it looks pretty decent. But, there might be counter considerations. And we've already spotted some issues, incidentally, for some counter considerations along the way. We already spotted some problems in the language of their employment agreement. We already spotted some problems in the assignment and it not being as expansive as it said. It might be a whole bunch of things, but, and it might be that there's some information they're not telling us, but, there's some other stuff there too. In response to request to add JLM's content on the main Instagram account, Gutman refused and again insisted the main Instagram is her personal. Gutman still refuses to return the Instagram account, continues to delete JLM posts, continues to post off-brand content, and refuses to post Sproul-related content. Gutman also refuses to return the account as well as the TikTok account, which may not belong to JLM for the reasons we discussed, also with the hashtag, with the same handle. And she may have to change the handle slightly to avoid some confusion there, but still, we can get into that. The main Instagram account belongs to JLM. It's never her personal account. Gutman has at least 2 other accounts. Miss Haley Clevin. Okay. And All That Glitters on the Gram. That's a pretty cool name. All That Glitters on the Gram. That's not bad. It's clearly these 2 are personal accounts, while Gutman has converted the main Instagram account to be her own business platform, as if she were an influencer. All right. So let's see what we think so far on the claims that we have. So we have trademark dilution. So when a trademark is diluted, right? The trademark is diluted because it is becoming unspecified. It used to be specified and now it is unclear. It's muddied. It's diluted. Like adding water to something. It's like adding water to wine or adding water to whiskey. If you add water to whiskey, the whiskey becomes diluted. It's not as strong anymore. All the whiskey fans in the chat say, no! Haha, I'm going to add more water to your whiskey. No! I'm going to add so much water, there's no whiskey left. Plaintiff has continuously used its registered marks as well as other designer names in connection to identify these goods. Based on the extensive sales marketing, they have distinctive and famous. Distinctive and famous is a legal thing too. Distinctive, yes. Famous, no. A famous mark is pretty hard to get. A famous mark is Coca-Cola. A famous mark is McDonald's. That's a famous mark. One of the benefits of being a famous mark is you get trademark protection in every class because it's a famous mark. Is JLM or Haley Page a famous mark? No. Vera Wang might be a famous mark. Haley Page, no. JLM, probably not, no. No. It's not for at least the reasons I had never heard of them. And famous marks have to be kind of ubiquitous. So, yeah. Upon information belief, the use of trademarks in connection with these goods constitutes commercial use. Yep. Upon information belief, the confusingly similar use of the trademarks and the Miss Haley Page trade name on the Instagram account, as well as defenders' efforts to positive endorsements, are eroding the distinctiveness of the mark. Yeah, a little bit, yeah. Upon information belief, defendants confusingly use similar names in connection with unauthorized use of the main account, as stated above, is likely to harm reputation. Upon information belief, defendants' use of the marks trade name began after the trademarks became famous. There's no way they became famous. Famous is a pretty hard trigger to pull. They're famous in their industry. Usually when we're talking about a famous mark and trademark, we're talking outside industry. Yeah, famous, I've never heard of like famous within an industry. Usually when we're talking about famous in a trademark sense, we're thinking cross industry. Coca-Cola is famous cross industry. They're famous ubiquitously. McDonald's is famous ubiquitously. Like, you don't have to be in their industry to know about, you don't have to be a soda manufacturer or a bottler or a ingredient provider or otherwise affiliated with the industry to know about Coca-Cola. You don't have to raise cattle or sell French fries or make menu boards or design restaurants to hear about McDonald's. They are famous because they are known outside their industry. They're known ubiquitously. I don't think this qualifies. Yeah, weddings may be multi-billion-dollar industries, but yeah. Upon information and belief, they became distinctive. Distinctive, I'll give you distinctive. Yeah, so that's fine. The trade name by less than capacity to identify the mark and distinguish it, I'll give you. Cause likelihood of dilution by harming or threatening the reputation, I'll give you. Threatened with dilution of its trademark rights as well as immediate direct industry to his name, I'll give you. Has willfully traded on the reputation to cause dilution? Yes. Plaintiff has no adequate remedy at law? Yeah, that's fair. Okay, I'll give you some of that, enough to make the count work. So not all of it works, but some of it works, so enough to make the count work, yep. Count 2. New York common law distribution. Well, I don't know New York that law, but I'm going to assume that it roughly parallels U.S. law, which is a pretty safe assumption. So if you're there under federal law, if you're there under the Lanham Act, we'll just assume you're there under New York law too. So yeah, let's take that as a given. False designation of origin. Through JLM's use of its design names and registration and tag tags, JLM has established ownership rights and the use of the names in commerce, including clothing, apparel, jewelry, and entertainment services. Not so sure, because we could discuss this, right? It's as long as it's wedding or bridal, but this is overexpansive. Constitutes false designation of origin, false misleading description of facts. To the extent that they're posting things unrelated to the business, like these third-party affiliate deals, yes, that would work. By reason of the foregoing, become confused. People might be confused about JLM and what it sells and what its products are and what JLM is as a company. Sure. You know, if BMW's main account just started posting things about refrigerators one day, you'd probably be confused. They started posting things about olives one day, you'd probably be confused. You'd be wondering, like, what does olives have to do with BMW? Maybe they're coming out with some new product. This is a tease. You probably have some questions. Likely cause confusion in the marketplace about the source, origin, or sponsorship. Sponsorship for sure. Their violation of the Lanham Act, yes. Causing confusion, irreparable harm, yes. So I'll give you that. New York law, unfair competition, we'll just assume it tracks federal law. Conversion is stealing. Yeah, that's easy enough. We got that. Unlawful trespass to chattel. adversely affect the condition, quality of the main account, had deprived them from the use of the account for a prolonged period of time. You got that. Breach of fidelity. During employment, actively and secretly took possession over the property. As a result of them, JLM has been frozen out of its main account while still employed. They did this unlawful acts of willful, deliberate, intended, and made in bad faith and damage thereby. I'm not sold. I'm not sold on this. I'm not sold on this. This is underspecified for breach of fidelity. They are not saying why she has a duty of fidelity. It's a little underspecified, so I'm not going to give them count 7. Count 8, breach of contract. Probably, almost certainly, right? Shall in perpetuity be exclusive property of the company. Shall no right to use the trademarks or any confusingly similar marks. And she is breach of contract by putting things up within the company. So breach of contract, we've got breach of fiduciary duty. Okay, this will be interesting. Does she have a fiduciary duty? Sell me. So main Instagram was linked to defense email. She has the ability to change credentials. This is particularly true. Reliance on JLM to protect their rights and created duty of trust and confidence. Fiduciary. No, she's not a fiduciary. She's an employee. She's not a fiduciary. If she were a business partner, if she were, in a protected role, but she's an employee. So I do not grant them breach of fiduciary. I do not grant them count 9. Count 10. They acquired benefit from the use of our property. We got that. She got money. She got money for herself by using our business assets to get that money. She has been unjustly enriched by getting that money. No problem. So we've got 7 or something. We got 7 of these counts. We don't have all 10, but we've got 7 of these counts. So yeah, there's a lot there. And therefore we want to be enjoined from using any of the marks, passing off, engaging, registering, adding posts, properly registering, or to deliver credentials, blah, 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 blah. We want a jury trial. Okay, yeah. So we have not got into, and I don't know, I honestly don't know because we haven't really gotten that far in this. So I don't know if there's been an answer in this case. But in my opinion, now I do understand there's been a preliminary injunction, but that doesn't speak to the merits, right? It doesn't speak to the ultimate merits. So I don't even know if there's been an answer in this case. But if there's not, in my opinion, Haley Page does have some counterclaims. She has some counterclaims relating to trademark and related to contract too. So she has some counterclaims to clear that up. So we'll see. But yeah, the non-compete for 2 years looks perfectly reasonable. A 2-year non-compete is a reasonable term. It should be tolerated. The name is a business asset. So for the nature of it, what they agreed to, which is the bridal aspects of it, then yeah, probably. So she can use her name, I would say, based on what I read so far, she can use her name in fashion. She just can't use it with respect to bridal design. So that's the way I would see this so far. So it'd be interesting to see how it gets interpreted. And it'll be interesting to see how it gets interpreted and stuff like that going forward. So we'll see. Really, really interesting stuff. Really interesting stuff. But I think JLM has the better end of the major issues. But I think Haley has some chances here. That would be possible. So we'll see. Yeah. So we'll see. And of course, she doesn't have to use her name in trade. That's the other thing too, right? So that's the other thing. I'm not using my name in trade, right? This channel is called Uncivil Law. My name is not actually Uncivil Law, right? So she doesn't have to use her name in trade. She could use a different name in trade. And, it's not like she can't. So some people misunderstand this. So let me clear this up right now. It's not like she can't call herself Haley Page. She doesn't have rights to her name. That's ridiculous. She has rights to her name. She can still call herself Haley Page. She can even introduce herself. She can introduce herself and talk about herself as Haley Page if she continues to work in the industry. It's not even like if she works in the industry, she can't call herself Haley Page. She just can't call the business Haley Page. She can't call the line Haley Page. She can't trade on the name Haley Page. She can call herself Haley Page. She can say, she could say, I don't know, what's a good name for a bridal design company? White Dresses Are Us. CEO Haley Page. She can do that. I don't know. Say Yes to My Dress. CEO Haley Page. I don't know. But yeah, she can use her name in business. She just can't use it in trade. She can't use it as the business name. She can't use it as the line name. She can't use it as the dress name. She can use it as her name. Some people seem really confused by this, including Haley Page, I'd like to point out, who doesn't seem to fully understand this concept for some reason. But yeah, she just can't use it as a trade name. She'll have to come up with a trade name. Apparently JLM thought JLM was a really good trade name. Maybe those were the initials of the founder or something. I don't know. But apparently she could call herself the SYB company. I don't know. We'll see. But yeah, we'll see how it goes. We'll do some more stuff later. For the 206 of you who are here, I really, really appreciate it. Thank you. So for everyone who is here, I want to say thank you for joining me on this first look at the Haley Page case. It'll be interesting to see how it develops. It'll be interesting to see if Haley Page has any defenses like I've thought about and what else we got. If you're enjoying this content, please remember to give the video a like and please remember to subscribe. It really helps the channel grow. Did you know for a mere 99 cents, you can become a member of the channel? It's true. You can help support the channel financially so that we have the ability to continue producing great stories for you and good stuff like that. So until later, my friends, I hope all is well. Cheers and goodbye.